Thank you, Chairman Ossoff. Good to see you in the chair. Welcome, Your Honor. Good to have you here. I think I'm the only First Circuit member on the panel, so this is terrific news for me to see you nominated by President Biden. And you'll have the terrific occasion to join what I think is a outstanding circuit. And I really look forward to having you there. I'm just delighted.
I concur with you. It's an outstanding circuit, Senator.
Yes. And the Rhode Island member is Rosary Thompson, as you may know, who I recommended to the president for that position, along with Senator Reid. And I think she'll be a wonderful colleague for you. And nobody else in the committee will know or care about this, but Suffolk University has been a very important law school for Rhode Islanders, and I'm sure you had a great number of Rhode Islanders in your classroom. So if you don't mind, we'll consider you a bit of an honorary Rhode Islander through your Suffolk credential.
I appreciate that. And when I went to Suffolk Law School, Rhode Island did not have a law school. So that's
correct. You were kind of
Rhode Islanders went to Suffolk.
Yes. But now we have our own, and it's a very, very good one. Roger Williams University School of Law. I commend it to anyone interested. So, two questions. The first is a legal question, and it relates back to the question of qualified immunity. Is it true as a factual matter of legal doctrine that the qualified immunity doctrine interrelates with other doctrines, including sovereign immunity, the Monell case doctrine, the Bivens case doctrine, and that they interact with one another?
In my experience in Puerto Rico handling civil rights cases, they are usually raised in the same cases that come before me because there is sovereign immunity many times for the state, but the officers are sued in both personal and private capacity. And qualified immunity will apply. The officers or government officials, doesn't have to be police officers, it could be government officials acting in any capacity. It is a doctrine that is frequently raised. And I do want to say it's not only, most people think it's only in the police context, but you can have a government official, a head of an agency who fires individuals based on, let's say, political patronage, and then you can raise the doctrine. It may apply, it may not apply, depending on the particular case.
And the reason I asked you that question is to highlight for my colleagues that I think we have an opportunity to clear up this area of law in the current reform that is proceeding by solving not only qualified immunity, but also, in essence, applying the ancient doctrine of respondeat superior throughout the system and eliminating what are really arbitrary distinctions between municipal, state, and federal law enforcement agencies with respect to civil liability, and I hope that we will take this opportunity to do that. The second question I have for you, Your Honor, has to do with juries. One of the things that we have seen in the Supreme Court has been a fairly persistent set of decisions that have raised the bars for plaintiffs to plead their cases in federal court, discouraging certain types of cases from being brought in federal court, undoing or restricting certain types of jury determinations regarding damages in federal court. And that is in some districts added to by pressure to settle cases rather than take them to trial. And the result has been described as a real crisis in jury trials in federal courts. We meet every year with my state judges in our district court, with Judge Smith, Judge McConnell, and Judge McElroy. And there was a time when they hadn't had a civil trial in a year because lawyers were discouraged from going to federal court and they had an exclusively criminal docket. I don't know what the situation is in Puerto Rico, but my feeling is that robust jury trials are a very important part of American democracy. And if you go back to the founding days and to the Constitution itself, the importance of juries and jury trials had great significance in the governance that the founders were trying to establish and in the principles that we fought a Revolutionary War over. And so it's sad to see the institution of the jury trial kind of wither on the vine. And I think it can be made more robust. There are judges who are going out of their way to make it more robust, I think successfully. And I'd like any comments you may have on that situation.
Senator, also, if I know the red light is on, but if I could answer the question.
Of course.
Senator Whitehouse, in Puerto Rico, in the federal court, there are a large number of jury trials, civil and criminal, conducted every year. One of the reasons is that at the state level, the local level, particularly in civil cases, there is no right to jury trial in civil cases. So attorneys try to go through diversity or federal question jurisdiction to the federal court. I'm a true believer in the jury system. I've had, as my Senate Judiciary questionnaire notes, I have presided, I believe, over 64 jury trials over the years, a few more when I was a magistrate judge, and it is a very important role that the jurors play.
Indeed. Thank you.
Thank you.
Thanks, Chair.